welcome to the Florida Mental Health Counselors Association webinar entitled A Unified Partnership Between Attorney and Mental Health Counselor with Adam Rossen, a licensed attorney at Rossen Law Firm. This is the 7th webinar for our 2019 Emerging Issues in Mental Health Counseling webinar series. My name is Aaron Norton, and I'm the chair of FMHCA's Education, Training Standards, and Continuing Education Committee, and I'll be your moderator today. I'm going to ask some questions about you, our audience, so that the presenter has a sense of who's out there today. We'll launch our first polling question, and that polling question should be on your screen right now. Which of the following describes you? And you can select more than one option if more than one applies. Your options are licensed mental health professional, registered intern, counseling student, counselor educator, or other. 88% of you are licensed, 13% are students, and 13% other. So we'll also move on to our second and final polling question. Which of the following learning objectives are you most interested in? Number 1, learn to establish a relationship with the client's attorney. Number 2, learn how to navigate the criminal justice system. Or 3, explore the pitfalls of the justice system and mental health court. All right, you have all responded 100%, so we'll share our results. 56% of you are interested in exploring the pitfalls of the justice system and the mental health court. And then an evenly split 22% both for learning to establish a relationship with the client's attorney and for learning how to navigate the criminal justice system. So now that we have a sense of who's out in the audience today and what you're interested in, I'm going to go ahead and introduce today's presenter. An award-winning attorney and former prosecutor with over 10 years of experience in both criminal and DUI law, Adam Rossen is a skilled lawyer who takes a multi-dimensional approach to get his clients the best results possible. Adam believes attorneys are named counselors for a reason, because their impact needs to go beyond the law. A high school basketball coach for over 10 years, Adam is a mentor and motivator who keeps his clients involved and on track all the way through so they'll continue to see long-term success well after their case is over. A lifelong South Florida resident, Adam has spent his entire career practicing here. He's successfully conducted over 50 jury trials and has handled hundreds of DUI, criminal, and domestic violence cases. A frequent lecturer, Adam regularly speaks on DUI, criminal law, and drugs, drug court, and addictions at various institutions, including DUI schools, Broward College, FAU, and a number of mental health treatment facilities. Ladies and gentlemen, please welcome Adam Rossen.
Thank you, Aaron. Thank you. Appreciate it and glad to be here. So first of all, we're going to be talking about everything that we have to talk about over the next hour and a half, 2 hours. For everybody listening, I want to let you know that I'm going to do 2 different Q&As. At the end of part 1, we'll do a Q&A, and then at the end of part 2, we'll do a Q&A. So definitely let me know whatever questions you guys have. I'm happy to answer and help out. And so the title of this is a unified partnership between legal and clinical services, basically between attorney and and mental health / substance abuse treatment counselors. And so who am I to be lecturing and teaching you folks all about this? Well, there's really 3 main components to me. Okay, there's the coach, the teacher, and the attorney. And so hello, I'm Adam. And so as an attorney, and like Aaron said, I was a prosecutor for 2 years in Broward County, Florida, so in Fort Lauderdale, which is one of the largest state attorney's offices and one of the largest just criminal justice systems in our state and in our country. Did that for 2 years, and I've had my own private practice, my own law firm that I'm the owner of for now the last 11 years. So I've been an attorney now for 13 years. And what I've noticed being down here in South Florida is I have a lot of clients that have issues and problems, and it ranges on the spectrum, right? There might be just depression or anxiety that's not severe, but it's affecting them, and it could be leading into what happened with the charges. It could be because of the charges, all the way to clients who are legally incompetent to stand trial. And I've just noticed throughout the years that there's a huge disconnect in between therapists, substance abuse, and the attorneys. And we all have the same goals in mind, but I think we're afraid of you, and you folks are afraid of us, and it really doesn't need to be that way. So that's a little bit about me, and really what brought me into this field of trying to educate, counselors and mental health and substance abuse, counselors and treatment facilities, so that people really understand that we're all in this together for the same reason, to help our mutual clients. I also was a high school basketball coach for 10 years, love basketball, love coaching, making a difference, and I do frequently lecture places like this on these issues, as well as just criminal law issues, where we can really delve into DUI and drugs and kind of the law and order, the fun stuff, where I get to meet people and tell people about what the law really is. So let me go back a little. So where did this really all start? Like I said before, just about me seeing this disconnect. But there was a client that I had, and I can't talk about this because this is, for us in criminal law, the cases, are public record. Maybe not the client communications and what we say behind the scenes, but the facts of the cases are public record. And a client of mine, basically, and you'll hear about him later in one of the videos that I play, but highly intelligent person who had mental illness, and he had a case that was it was a felony, not the world's most serious felony, but it was a felony nonetheless. And in representing him, we tried to get him help go through the Broward County Felony Mental Health Court program, and the whole system failed him. It was very sad. And for me, looking back, because that was about 5-6 years ago for me when I represented him, just looking back, that was also one of the real key cases that I had that made me think and realize, hey, we all can do this better. We need to do this better. So we have a few learning objectives for today. So the first one is how to, as Aaron stated before, how to navigate the criminal justice system and develop an understanding of what your client is going through. Basically, so that way you folks, can learn about what we have to deal with, what our goals are, what the criminal justice system's goals are, what the prosecutor's goals are, and what the judge's goals are. Okay, because they're not, a lot of times it's a triangle, and they're kind of, they're competing against one another. We have the pitfalls of the justice system and the mental health courts, right? And how a lack of education on both sides can hurt your client's case. Just by not being aware, by not understanding, clients can get worse results than if they have a counselor or an attorney who understands the need to work this together. And that could be something regarding behind the scenes plea deals just worked out between the prosecutor and the defense, or that can go all the way to downward departures to open pleas with the judge, where the defense and the prosecution can't agree, but the defense would be asking the judge to basically go below what the prosecutor is wanting and make a different sentence. And the third learning objective is how to establish an effective partnership with your client's attorney that, again, we can work together. So really all three are interrelated. They're, at the end of the day, they're all about just how can we work better together. The last thing that you ever want is to have a client come see you on Thursday or Friday, knowing that they have court with me or their lawyer on Monday or Tuesday, and then you find out a few days later that that client went to prison for 5 years, for 3 years, for a year, for however much, because then in your mind you're going to say, oh geez, could I have done more? It is a great quote, and this is from Judge Leafman from the 11th Circuit, which is Miami. okay? And he said, when I became a judge, I had no idea that I was actually becoming a gatekeeper to the largest psychiatric facility in Florida. And sadly, that's the Miami-Dade County Jail. And now that's not limited to Miami. So in our country, the largest providers of psychiatric services are the jails all across, and of course, the largest cities. Now, Aaron, I have a question for you. Can the people on here, can we just open it up to a quick chat for people to raise their hand or say yes and no if they knew that?
We can. There are two ways that we can do that. We can have people raise their hand. So folks on your on the left side of your GoToWebinar control panel, there's a little circular symbol that looks like a hand. And if you click on it, it'll raise your hand. So we could do a quick poll that way. Would that work for you?
Okay, sure. I might not know how to see it, but I'm sure you can tell me how many people raised their hand.
I sure can. So is there a question that you were already going to ask? Or?
Right. Well, I just want to know from the audience of how many people knew that in our country, the largest, psychiatric facilities are the jails in the big cities, in Chicago, LA, New York, Miami, so on and so forth. So.
Okay. So everybody raise your hand if you already knew that. So far there are here we go. 1, 2, 3, 4, 5. Let's see here. There out of 12 people, there are 4 or 5 of them who raise their hands. Yeah.
Okay. All right. Good.
And you can go ahead and lower your hands now, so that way if we have another polling question, we can reset.
Yes. You can take the hands down. All right. Thanks, Aaron.
No problem.
Yeah. So a little, close to half, right? And I can tell you this, as an attorney, living it, breathing it every single day, right? The only area of law that I've ever practiced in my career, a total of 13 years, has been criminal. 2 on the prosecution, 11 on the defense, and I didn't know that until I started doing the research and trying to learn more about this. And Judge Leifman is a great judge, and you'll in one of the videos that we play, you'll hear also some more quotes from him. Now, some more, I don't want to say fun facts, right? Because they're not, but some facts for us to know. The people in jail with a mental illness, they stayed in jail 4 to 8 times longer than somebody who does not have a mental disorder. And we're talking the same charge. We're not comparing apples to oranges. In this, we're comparing apples to apples. So for the same charge, they're going to be in there 4 to 8 times longer. So think about that. If we're talking a year in jail, that means somebody that has a mental illness, right, on average would be 4 to 8 years in jail. If we're talking an average of 10 days, then it would be 40 to 80 days longer. Now in 2014, Florida spent the least amount of money in the nation per capita on mental health care, okay? 50 out of 50. To me, that's just, there's no excuse. It's outrageous. And that's basically $35.06 per person on that, and no excuse. I don't know if you folks know about the recent change, the new law that was passed, and this is something that's not in the handouts, but there is a step, at least a small step in the right direction with the new law for requiring, I believe it's 6th through 12th grade students in school. So I think it's a middle school and high school now require 5 years of mental health training or mental health awareness per year. So Aaron, did you actually know that? I don't know if you saw that, but that came out in the last, I think, week or 2.
I did not.
Okay, because I was actually at a panel on Wednesday night where, well, I found this out before, about 2 weeks ago, but that was a big discussion of a mental health panel that I wasn't a part of, but I was in attendance, and they further mentioned that. So I think it's a step in the right direction.
I'd seen some older stats. I saw some older stats that showed us being ranked number 50 than 2014. I think we've been in that slot for a long time.
Yeah, yeah. Well, and I think it starts, forget about the criminal justice system for a second, but if we're going to start, we got to start early. We got to start with the parents. We got to start with the kids, because a lot of the juveniles that do have issues, get in the juvenile criminal justice system and then progress into the adult criminal justice system. But at least that is something that's very recent. You can probably Google it and learn some more about it. But starting in, I think, 6th grade, in middle school and high school, every year, every kid in Florida public school is going to have to do 5 hours of some mental health awareness, mental health kind of just discussion and training and classes. So now, overall, the past 20, 30 years, the overall number of people being put behind bars in general has decreased. The quote unquote tough on crime laws in the 80s and early 90s have largely been proven to be a huge mistake. And so as the overall numbers have decreased, but the proportion, the percentage amount of prisoners with mental illness is going up. So you have the overall going down, and you have the proportion of people with mental illnesses increasing. And of course, we know that's not good. That's the exact opposite of the way that it should be. And it's estimated that 1 out of 2 people with a serious mental illness in our country will be arrested at least once in their lifetime. Okay. Most of the offenses that land them in jail are minor. So, we have a lot of loitering. Loitering and prowling can be anything from what we call a pre-burglary, meaning good police work. They stop somebody peering into cars or houses, or it could just be somebody panhandling on the side of the road. It could be just somebody hanging out at a 7-Eleven, somebody who might be homeless or just, hanging out there and they're not supposed to be. We have disturbing the peace and public intoxication, which are usually very similar to one another. But those are common crimes that are misdemeanors. In the grand scheme of things, they're not the most serious. Most of them have a max jail of between 60 days and 1 year, depending on the level of misdemeanor that it is. But the police are still, in a lot of counties, arresting people for those crimes, and they don't have the money to bond out, and they sit there and they spend a lot longer in jail because they don't have the family support to bond them out or to hire a lawyer or handle the case. So it's kind of a cycle, where these people are getting arrested, they're getting, for again, minor crimes, getting locked up, and they're sitting there and sitting there and sitting there, when really, especially for those minor crimes, most of those people, they need help, they need treatment. Now, these are some stats from the Florida bar. Okay, 17% of adults booked into the jails have a serious mental illness. 65% of adults in the U.S. correction system have a substance abuse disorder, and 72% with serious mental illness also have with serious mental illness have a co-occurring substance abuse disorders. So the numbers to me are pretty staggering. To me, those are significant numbers. They're not minor, they're not marginal in any way. And as I'm sure you folks, the ones who have their private practice or the ones who see clients on a regular basis, know that they often are dealing with these issues with their clients. Now, the arrest process, even if you've never been through it, you don't know. And even if you have been through it a lot, yourself personally, which luckily I never have, but I've been through it, through hundreds and hundreds of clients. But it's not designed for the average person. Okay. As we as a society are starting to destigmatize mental illness and destigmatize substance abuse, the police officers are getting more training, but the training is bare bones. Police officers, they are in a high stress situation, not to mention being arrested, yourself or for your client, but the police officers, their number one job is to be in control. Okay, that's what they're trained. If they're in control and they can control the situation, they can protect themselves first and everybody else second. They don't come into situations to be therapists. They don't come into situations to be mediators. They come in to gain control, to diffuse the situation, and then figure things out later. So the whole process is really, the exact opposite of what should happen when you have somebody with a mental illness. Now, to that person, right, that individual being arrested themselves, it is high stress, okay? And, most of the clients that I deal with, they do have high anxiety, high stress. A lot of them can panic, and these could be a lot of, this runs the gamut of my clients, even the ones that just get arrested and don't have any mental or emotional disorders. It's intense and life-changing for anybody, right? And I believe it's so much more amplified when you have somebody that does have a mental or emotional disorder. Now, once you get arrested, you're being taken down to the station. You're going to be put in a cell. You'll be taken to usually the county jail. So it depends on the police department. Some police departments will take you to their holding facility first, or their substation, which usually has a few cells before they take you to the county jail, depending on the crime, depending on the jurisdiction, or they'll just take you straight to the county jail. Now, in Florida, you must see the magistrate judge or the first appearance judge, usually within 24 hours. This, according to Florida law, these courts are there every single day of the year. I've been to first appearance court on Christmas Eve, Christmas Day, New Year's Day. Throughout my career, it is what it is. We get the call and we show up. The courthouse may look closed from the outside, but it's not. There's, they have a skeleton crew, and there is court every single day of the year. But sometimes you can be in there quite a bit. So for longer than a day. So for example, Broward County, where I am in Fort Lauderdale, we have magistrate court Monday through Friday, twice a day. We have a morning docket and an afternoon docket, and that's only been there for the past maybe 5 years or so. And the reason they did that is because they want to, there's really a movement to get people out of jail faster. So, which is good. I don't know if all of the counties, especially the smaller counties in Florida, probably don't have that. But on the weekends in Broward County, there's only a Saturday morning and a Sunday morning. They don't have afternoon. So for example, if let's say there's a domestic violence case that happens Friday night at 2 a.m., really, so Saturday morning at 2 a.m., and by the time that you're processed, booked, and everything, you're going to miss that Saturday morning docket. So you're going to be in jail for the Sunday morning docket. So you're going to be sitting there, right? Early morning Saturday, all day Saturday, all night Saturday, the morning on Sunday. And once you get there on Sunday, they're finally going to set a bond. But once they set that bond, it usually takes another 12 to 16 hours to bond out, assuming that either that person has the money or the family has the money, and they do so right away. So that person who gets arrested in the wee hours of the morning, Friday night / Saturday morning, they might not be physically released from custody until Sunday night or even the wee hours of Monday morning, okay? Now, when you do go to this bond hearing, there are some other things that can be done in lieu of a monetary bond. So the judge can set a bond and say it's $1,000, it's $5,000. The judge can also release you on your own recognizance, meaning a promise to appear with no money or no conditions. That is usually good for low-level crimes and for people who have ties to the community, meaning South Florida or residents of the community, residents, business. They have family there, they're involved, right? There's no reason to expect that they would flee. And for people who have very little or any prior criminal history. Some other type of conditions could be supervised release or pretrial release, and that can involve a whole host of conditions such as drug testing, GPS ankle monitors, anger management. If there's a victim in the case, it would be no contact with the victim. If the victim is a business or a specific location, it could be no return to that location. And so those are all other conditions. Now, depending on the case, the severity of the case, we, as lawyers, especially as defense lawyers, we may want those conditions. And I'm going to talk a little bit in the future about why some of those conditions could be good for your clients. So what do? Right? You get a call from a client of yours who says, my son or my daughter, was just arrested for such and such. Well, our recommendation is that, you don't want to leave somebody in jail to punish them. If you're the family, if you're the loved one, right? It can hurt them. It can hurt, our ability to defend their case, and I think it can kind of perpetuate and amplify the issues that they're going through if there are mental health issues. Now, here are some of the other issues. For serious cases, there could be jail rats, but all of the calls are recorded. So even if we're not talking about the murder case where the cellmate then, through their lawyer calls the prosecutor to get a better deal and rat out his cellmate, all the calls are recorded, meaning people call their families, loved ones, and even though it tells them, hey, this is recorded, this is going to be used against you, people still talk. On my side, we want our clients to be quiet from day one and don't make any admissions, don't talk about anything unless it's in a safe environment, in our office with nobody around. But also there's a tremendous lack of communication. It's hard, yes, they are allowed to use the phone, but it's difficult. It's only at specific times. Jail visitation in person is hard on the person in there. It's hard on the family members. And, we don't want to use jail as a detox method, okay? To me, I think this one is big. We see it time and time again. Jail's not a safe place to detox. Yes, they have nurses, they have doctors, they have medical facilities. It's not the same. It never is, okay? It's not what you'd want to be in. It's not what I'd want to be in to do that. If it were me or my loved one, I would want them in a nice facility where they have the professional expertise and just a whole system where that's all they're dealing with, not where they're worried about, somebody accused of murder and somebody accused of rape, and then Johnny who's detoxing from drugs, all at the same time, okay? And I also believe that it does criminalize that person, for their addiction. So what alternatives do we have, right? There is something called the Marchman Act in Florida, which, I'm not here today to go into the ins and the outs of the Marchman Act, but for anybody that knows that sometimes, not all the time, sometimes it can be fast, but quite often it can be slow and tedious, a slow and tedious process. So one of the things that I recommend, and now of course it takes family to be supportive and on board, but from my perspective, if the family is there, and keep in mind, usually I'm being hired in this situation by the family for, we'll say the teenager, for the young adult, in this particular incident, or whoever it is, for the client. And of course, I still have to do what's best for the client. And, I represent the client, not their family, right? But if the family shows up, or even if the client knows and understands that he or she needs treatment, we can ask for these conditions at that first appearance court, okay? The problem is when the attorney's hired 7 days, 14 days later, and the client's out of jail. But when we get hired right away, we can show up to first appearance court. If the family members are there, they can talk to the judge and they can say, Judge, we need restrictions on Johnny. Johnny has a substance abuse issue and we want him to be court ordered to a detox or court ordered to a rehab, or at least at bare minimum, court ordered for a mental health or substance abuse evaluation and any recommended treatment and follow-up upon release. So at least, and usually we can have that done within 7 or 14 days where the person gets out. They have to do it. And if they don't do it, whatever the terms and conditions of pretrial release are, they're going to go back to jail. And what I've found is for a good amount of my clients, the threat of jail hanging over their head is a good motivator, is strong. Not for everybody, as we know, but it definitely is a good motivator, more than than some other things for my clients to get treatment. So that's an alternative. It's not perfect either, but that's definitely something else through the criminal court where you don't have to wait on a Marchman Act. You don't have to wait on any of those other issues if we can get the court to order it right away. And if you can't, then Marchman Act would be a good idea. Now, as of July of last year, Florida has 23 mental health courts operating in 14 judicial circuits. In Florida, there's 20 total judicial circuits. Okay, so what is that? 70% of the judicial circuits have mental health courts. There's two main types, misdemeanor and felony. There's a lot more felony mental health courts than misdemeanor, but there are a few misdemeanor mental health courts throughout our state. And clients must be evaluated by 2 independent doctors. They have to be declared incompetent to proceed. And you'll see from some of the slides coming up and the video that in theory it's good. Like a lot of things that we do, it's a step in the right direction, but by no means is it perfect. And when you have big government, when you have just so many moving parts, unfortunately people can slip through the cracks. But the mental health court, of course, and my issue, one of my big issues with this is that the goal is really to restore competency. The goal is to basically say, all right, well, you might still have issues, but you're no longer incompetent. So now we can prosecute you, and now we can, hold you accountable and criminalize you and criminalize the behavior, instead of it truly, in my opinion, being a truly therapeutic court, instead of it really being like that. And I think that's also one of the issues and problems that you'll see from the video that I play. Now, so misdemeanor mental health court, the very first one was in Broward County, so we were good with that with Judge Ginger Lerner Wren, and that handles usually non-violent misdemeanor defendants who are mentally ill or developmentally disabled. Now that focus for the misdemeanor mental health courts is more on treatment, because especially down here, people get out of Judge Lerner Wren's way and they let her do her thing, which is fantastic because she genuinely cares about helping people and about treating people. And she's the perfect judge for all of this. Okay. And the goal in the misdemeanor side, because we're dealing with trespass, loitering and prowling, right? It could be a misdemeanor battery, which in the state of Florida is an unlawful touching against your will. So as you'll hear in the second video that I play, who the lady was accused of domestic violence battery, it's not what she was accused of doing is not what you think of the minute or the second that you hear me say the words domestic violence battery. We all in our mind take that to a Law and Order, to a Channel 7 news kind of thing, when a lot of times it's not to that level. So, but these cases are usually the goal is to resolve them quickly, and misdemeanors in the state of Florida can carry a max penalty of up to a year in jail. Some of them can have a max penalty of 60 days. Okay, so we're talking, a lower level of offenses. Now, so on the felony mental health court side, these are the felony cases, right? Now, This is more focused on punishment than the misdemeanor mental health court is. And like I said before, the goal is to treat and stabilize incompetent defendants so that way they can be held accountable, which really means prosecuted, punished. Okay. The qualifications are the same as far as being able to get in. It's just we're talking about higher level crimes, although a lot of third-degree felony crimes can still be relatively minor. And third-degree felony crimes are crimes that are punishable by up to 5 years in prison. And those can be burglary of a car. That can be basically opening an unlocked car door to see if there's money or if there's a purse. You don't even have to steal the purse or take the money. All you have to do is just open an unlocked car door and you're charged with burglary. Not smart, definitely a crime, something people shouldn't be doing, but that is, still a felony where you could be looking at up to 5 years in prison. Okay, now some more of the lowest level third-degree felony charges. So this one, $300 of shoplifting or any kind of theft. This is important. Since 1986 until this year. So what's the math on that? We're talking 33 years. The threshold for felony versus misdemeanor has been $300, and they have not once in 33 years until this year increased that for inflation. Okay, so imagine the last 5 years, 7 years, 10 years, right? It's so, it's a lot easier to steal some $300. Could be 2 shirts from Macy's, could be 3 shirts from Macy's, depending on what your taste is or what the client's taste in items is, and you could be hit with a felony charge. Now this year, again, step in the right direction. Is it enough? I don't think so, but it is a step. And before I go into that, across the country, most states have increased the threshold amount over the last 5-10 years. And, it took us 33 years to increase that. But we have increased that. Starting October 1st, it will be $750 instead of $300. And there was a big battle in this year's legislative session. They wanted $1,500. $1,500 was said no way. Then they went down to $1,000, hoping that would pass. They could not agree either, and they settled on $750. So, definitely, I believe a step in the right direction. So, like what I said before, entering an unlocked car is a burglary of a conveyance. Okay, drug possession. So, all drugs in the state of Florida are felonies, except for marijuana. Under 20 grams. So if you have 20 grams of weed, or more, then it is a felony. If you have 1 Percocet without it being in its prescription bottle, even if you're lawfully prescribed that, we're not talking abuse, we're talking legitimate lawful prescription. If you have that in your purse or in your pocket because you're lazy, because you're ignorant, because it's an inconvenience to carry around, pill bottles, right? Or because, for example, those are examples of if it's even lawfully prescribed, that 1 pill is a felony in the state of Florida. Okay. Also, before we go into the property damage, for example, the e-cigarettes and the liquid THC, the liquid THC oil, that is a felony. So you can have minor amounts of liquid THC, in a vape pen, and the way the law is written, that's a felony right now. So we've handled a lot of those cases. $1,000 worth of property damage is called criminal mischief here, or AKA vandalism. And that, $1,000 or more is a felony. But the issue with this that we've seen, and I've had plenty of cases like this, but this is another case where the amount really controls. It's not so much the action that controls whether it's a felony or a misdemeanor. It's the damage or the amount. So you can have two people do the exact same thing to a Toyota, right? Kia Toyota, Kia Maserati. Well, the person that has the good taste and keys in the Maserati, they're going to be hit with a felony, most likely. Okay, because if that causes $1,500 worth of damage, we're talking felony. And if you key up, you know, a 1988 old Toyota and the damage is only $400, that person's getting charged with a misdemeanor. And these are all examples. Yes, they're all felonies, but they're all low level, you know, third-degree felonies. So this is a great video from the Sun Sentinel that is going to give some more in-depth information about the felony mental health courts. And this was from Broward County, from Fort Lauderdale. This was about 4 or 5 years ago. Hopefully it's going to be loud for you folks. I'm going to take off my earbuds and I'm going to put on some external speakers so that everybody can hear it. But what I want, well, there's a bunch of things to really pay attention. I think this is a fantastic video, but I want you folks to really listen to the perspective of the state attorney, Mike Satz, who has been the head prosecutor here in our county since 1976. I worked for him for 2 years, and he's actually retiring next year. So I know I was born in 1981, and he's been the head prosecutor for 5 years longer than I've been alive. And think about how much our world and society and our beliefs have changed in that time period, and just listen to his comments and issues with the mental health system and the mental health courts. So I'm going to go ahead and play this, and let me know if you can't hear it.
Clovis Nelson said he hoped one good thing might come from his daughter's arrest. Maybe, he thought, Broward County.
Aaron, can you guys hear that okay?
Yes, we sure can.
Perfect. All right, I'm going to go ahead and play.
County's felony mental health court could help Catherine, who was diagnosed with schizophrenia soon after graduating from Coconut Creek High School.
When I first heard about the mental health court, I thought to myself, oh, this might be a situation where, you know, she will get help, real help. Instead, it turned out to be a penal process.
Catherine Nelson was trapped in this parallel court system for 6 years, too sick to stand trial, but never set free by prosecutors. In a 6-month investigation, the Sun Sentinel found that defendants in Broward County's felony mental health court spend more than 6 times longer in the criminal court system than those in regular court, an average of more than 3 years compared to 6 months. Nearly a third of them, like Catherine Nelson, spend 5 or more years in mental health court without being convicted. Even Ari Porth, one of the 2 judges who preside over the court, acknowledges that it's troubled.
There are some people I just feel like we're wasting a tremendous amount of resources. They're not learning anything new. They might not ever learn anything new. So we're just spinning our wheels.
Broward County's mental health court launched 12 years ago with a dual goal, treating mentally ill defendants while holding them accountable for their alleged crimes. The Sun Sentinel found a system built on good intentions has gone awry. Reporters found the problem starts with the Broward State Attorney's Office, which for years has refused to drop most cases against people too sick to face their charges until forced to let go by the state. Prosecutors pursued charges against Nelson, even after the judge on her case urged them to drop it. Police arrested Nelson in 2009 when she was a 20-year-old Broward College student. Nelson snatched a woman's purse on a public bus, then quickly dropped it. Nothing was taken and no one was hurt.
She has no criminal record. She was a scholar, a bright student up until all of this happened.
Prosecutors dropped Nelson's 6-year-old case in November after the Sun Sentinel raised questions about it. Broward State Attorney Michael J. Satz declined to comment on camera for the story, but promised to examine any long cases brought to his attention. Certainly, mental health court is not perfect, Satz told the Sun Sentinel. That's why we were thinking, what else can we do? Prosecutors said defendants who fake or exaggerate mental illness in the hope of avoiding prison time are responsible for delays in some cases. Prosecutors also said holding on to charges allows the court to supervise mentally ill defendants, provide them access to treatment, and ensure public safety. Jeff Marcus, an assistant state attorney, said, quote, "If you dismiss the case, what's protecting the community? Nothing." Felony mental health court judge Mark Spicer said he was frustrated by the length of time some defendants spend in the system.
There's a lot of people that are just going on and on and on, under the court supervision. But I don't like. I'm not the prosecutor, and I'm not the legislature.
Joshua Stein's parents struggled to understand how their mentally ill son ended up facing felony grand theft and burglary charges after taking a red-footed tortoise from the South Florida Wildlife Center and later returning it. Their son's childhood passion for turtles and tortoises had followed him into adulthood. Diagnosed as bipolar, he lived with his parents because he couldn't manage his illness on his own. He threw himself into collecting and breeding turtles and tortoises, filling his parents' sunrise backyard with them.
Joshua Stein was someone that had a mental illness, but was a caring individual. And because he was a caring individual, he acted the way he did. Where is the public safety threat for someone like Joshua Stein?
In felony mental health court, caseworkers complained to Judge Spicer that Stein was uncooperative and adversarial. They said they didn't know whether he was taking appropriate medications. Judge Spicer ordered Stein to wear an ankle monitor and placed him under house arrest after he repeatedly missed meetings and failed to follow caseworkers' instructions. Spicer told the Sun-Sentinel the court requirements were intended to help Stein, not punish him. But Stein's parents said mental health court only hurt their son. The ankle monitor, they noted, didn't even permit him to go into the backyard to feed his beloved turtles.
Instead of helping and treating him, they did the exact opposite. They made him feel worse and exasperating the whole system.
Stein died of an accidental drug overdose in December of 2014 before he could stand trial. For more than a year, mental health advocates in Broward have urged prosecutors to start sending mentally ill defendants facing minor charges to treatment instead of court.
Bottom line is, somebody did not commit a violent crime, they're mentally ill, you know that they're never going to be restored to a full sense of competence. Why are we playing this stupid game?
In December, the Broward State Attorney's Office kicked off such a program, modeling it after the 8-year-old felony diversion court in Miami-Dade County. Miami-Dade sent nearly 1,000 mentally ill defendants for treatment rather than prosecuting them. Judge Steve Leifman helped create that program.
If we can prevent people from getting sicker and keeping them out of the criminal justice system, it's going to do a lot of things. It's going to improve our public safety. It's going to save the taxpayers a lot of money. And equally, if not most importantly, it's going to give people with mental illnesses an opportunity for recovery, hope, and lives.
Broward's new program may divert as many as 60 mentally ill people into treatment programs over 5 months. But it fails to address the biggest problem the Sun-Sentinel found: the length of time people like Catherine Nelson get trapped in the court system.
Why should we care if someone has cancer? Why should you care if someone has a heart attack? Is there any difference? It's discrimination, not to. It's offensive. They're just illnesses. And it's not willpower. They didn't wish to be born with schizophrenia or bipolar disorder. They're not bad people. They're just sick.
Okay, so Aaron, can everybody hear me?
Yes, we can.
Okay, wait, let me turn that. I don't know where that came from. Okay, so when you hear that, first of all, you hear from the prosecutor, Mike Satz, and Jeff Marcus, who are basically saying, well, we need to protect the community, and by keeping them in this and making them show up to court and, and hanging them in, having them figure out a way to get to court, stressing and worrying about parking, going through a big scary 30-story building, going through metal detectors, being subject to a search. If they're not there in court on time, the threat of a warrant, being in quote unquote the system, and they want people to stay in this system, to protect the community, to protect the public. But then you hear from Judge Leifman down in Miami who's saying, no, if we actually help these people and get them out of the criminal justice system and out of court, that's how we can protect the public. And to me, I think it definitely shows you the difference of, now look, not all state attorneys, state prosecutors are like that, but at least where I am down here, they are, and it's been that way for over 40 years. Miami has this program, and I don't know if you heard or picked up on it, because the video was a little long, but they said there's been 1,000 people go through, and this article was from about 4 or 5 years ago, and they were saying, well, in Broward they might get 60. So the neighboring county, you've had 1,000 going through and getting these services through a mental health diversion court, where the goal and the process of a diversion is different. It's to get them in and out, to divert them out of the system, as opposed to keep them so that way they can be tried and punished. But you have 1,000 there, and this new program 5 years ago, they're talking 60. To me, those numbers again are astounding. I can tell you since then, most lawyers, most of my friends, contemporaries, they don't even know about this program. The mental health diversion, it's not even listed on their website. It's not listed under the diversion programs, okay? If most of the expert criminal defense lawyers don't even know it exists, right? How does the public gonna know? And think about this. You have a video from years ago saying, well, yes, we should change, we should make it better. And then they're deliberately hiding the program, right? Again, these things to me, with the courts, the way they do down here are baffling. I did this lecture last year live, and there was somebody from Tampa, actually a public defender who came to the lecture from Tampa and told me about their program, and their program is wonderful. She said, there's some that they're really truly, it truly is different than down here. So that's good. It's hopefully, as more and more of this goes on, that all across our state we can have, not just in Miami and Tampa, which are the only two real ones that I know about that are truly mental health diversion courts. Hopefully it can spread to Jacksonville, to Fort Lauderdale, Palm Beach, Orlando, and then all throughout our state, even in the more rural areas and the rural counties. Okay. So, and just like what we heard, the time is significantly longer. One of my regular felony cases might take 6 to 9 months for us to work on, and the average person, the average in felony mental health court spends more than 3 years. Okay. Now, like we heard about, when you heard about Josh Stein in the video, if you miss treatment session, if you miss court, if you have an issue, we could talk about warrants, increased sanctions, ankle monitors, house arrest, or even just simply, locked up and put in jail. So again, there always is that threat of punishment for what are seemingly minor mistakes that for maybe you or I, we wouldn't be as, our potential to make those minor mistakes are probably really low. But somebody with serious mental illness to the point they're incompetent to stand trial, the percentage of them having those issues, being late, missing an appointment, not having a ride, not being, if they don't drive, or right, they don't have a license or are incapable of driving, it's difficult in a large metropolitan area such as South Florida to get places on time, and it further exacerbates the issue. Since 2003, the number of mentally ill people in Broward jails have almost doubled. Okay, and so Florida law requires that, what they were saying in the video, you have to be incompetent for 5 consecutive years. Well, what if you're incompetent for 4 years and then 2 doctors say that you have been restored to competency, and let's say you're restored for 6 months and then you become incompetent again? that clock, that 5-year clock for dismissal restarts. So that's one of the main reasons why people in felony mental health court can be there for years upon years upon years. Now we have drug court, okay? And I believe we'll go through drug court and then we'll end section 1, and we can, hopefully you folks have some really good questions that I can answer for everybody before we move to part 2. One good thing about us in our state, we did start the national drug court movement in 1989, and the first drug court was, in Miami-Dade, which was fantastic. As of July last year, Florida has 94 drug courts, 46 adult felony, 7 adult misdemeanor, 22 juvenile, 15 family dependency, and 4 specialized DUI courts. Okay, so what are really the components of drug court? Drug court is supposed to be therapeutic, a non-adversarial approach. They want to get people into drug court early on in the case. They certainly don't want cases to linger for months at a time before people go in. There's alcohol and there's drug testing. There is coordinated strategy. There's usually a lot of moving parts with it. There's quite a bit of court dates based on the monitoring and the evaluation process. But the great part about drug court is if you get in, if you complete it, guaranteed the charges will be dismissed, okay? Which, from my perspective when dealing with clients, that's fantastic, because there's, I may see a case right away from day one and think it's a great case that we can defend. There could be problems from the prosecution standpoint, but that doesn't mean there's ever a guarantee that we can get the great, the great results that our clients want. And when you have something like drug court, it's hard to pass up for my clients. Plus, I've seen firsthand drug court work wonders on certain clients, that have had very serious, drug issues. Okay. Now, how do you qualify? So first of all, you have to be assessed as having a substance abuse problem. It is voluntary, meaning they can't force you to go in. Okay, so you have to have a problem, right, involving substance abuses, want to go in. Okay, you can't be charged with a crime of violence. Can't be a previous convicted felon or be in a previous pretrial program, and no dealing drugs. Okay, so that a lot of times that is something that we see often and have to fight to argue with the prosecutors and the judges about. We have certain clients where, if you think about 20-year-old, we'll use 20-year-old Johnny, okay, who's a college kid, and he buys, he buys an ounce of weed at a time, and he sells it to his friends so he can get free weed, free drugs. He's not Pablo Escobar. He's not a big-time drug dealer. He's just, basically buying, right? He's actually, if you think about it, he's a smart entrepreneur. He's saying, well, if drugs cost me this much and I can buy a little bit more and I have friends that want it, I can sell it to them and then I make some money and basically just get free drugs. Now, of course, most people don't look at it that way, and I'm being a little bit facetious about that. But is that really the person who we should disqualify from drug court? Because we know he has a problem, right? We know he can use and needs the help. We certainly don't want 20-year-old Johnny to become a convicted felon and lose his civil rights for something like this. He's not Pablo Escobar. He's not importing large, quantities. But that's something that we often have to deal with and fight with. The other common thing that we deal with, fighting to get clients in accused of dealing drugs, could be somebody, client who just is a heavy smoker. If you know who Snoop Dogg is, he's not buying this much of weed at a time, right? And I have a lot of clients who are heavy smokers who might themselves be buying, an ounce or two at a time, not selling to anybody, but they purchase, you know, a week, 2 weeks, a month's worth at a time because it's cheaper, and they know they're heavy smokers and they're going to go through it. And we have to fight that, you know, the prosecution and the judge is thinking that that is evidence by itself of dealing. Okay, and again, that could be very well somebody who needs, you know, the exact person who I believe drug court was designed for. Okay, I've had other clients, you know, serious drugs, meth, heroin, right? Obviously with fentanyl and oxycodone and all those drugs, and I've had prescription as well. I've had clients who are on the verge of death and gone through drug court and, you know, turned everything around. So there are some real significant benefits for drug court. Now, of course, let's talk about the pitfalls, right? We do, you know, have a lot of clients who don't take it seriously, or who seriously struggle to get clean. It is a therapeutic court. You get punished if you lie. You don't usually get punished right away if you use. But if there's a continuing pattern of use, and it looks like they're not taking it seriously, or they're absolutely doing nothing to get better, the judges will give sanctions. You know, the sanctions will go from anywhere from community service to more classes to even to higher levels of care, or even jail. In Broward County and in most of the counties, they do have at least one drug treatment program in jail. So in Broward County, we have something called SAP, Substance Abuse Prevention. It's a 30-day program with about a 2-week wait. And the judges, you know, if you're not getting everything done right, they will put you in there. They'll lock you up and put you through SAP to kind of reset you. And then from there, you know, go down the level to different varying levels of care. Okay. Like I said, lying, you know, is not allowed. It is a therapeutic court, and the judges are pretty good about letting people know that. Okay. It is a lot of work, though. You know, one of the things that I have clients, you know, we always have this real talk, right? And a lot of my clients say, yeah, Adam, but I can't stay clean for that long, or I don't want to, right? It's just weed. It's just, you know, I got caught with 30 grams of weed, Adam. It's just weed, or it's just, you know, I like taking, you know, Xanax every once in a while, right? And I don't want to stop. You know, and that's something that we run into because it is voluntary and it's a lot of work. We have a lot of clients that say, well, out of my work, and I work so much, and there's just no way I can go to all of these classes and all of these drug tests and everything that they need me to do. Okay, and so those are some of the pitfalls that, you know, it's difficult. Okay, but then again, it's only difficult, my belief is if you don't make it a real and true priority. There is, you know, a lot of individual and group therapy, random test results. You know, it's hard. You have to continually call in and see if your color is being called. And if you call in and they say, hey, today is purple, and you're purple, you gotta, you know, not drop everything you have to do, but by the end of that day, you better give a urine test, okay, or else you're in violation. So it can be difficult. So now, before we go into part 2, I wanted to, Aaron, if you're okay with that, I wanted to maybe open up to a few questions now, just so that way people who maybe have had questions don't have to wait to the end. I think it'll be a good time for a little break.
Absolutely, I'd be happy for us to do that. So far, there aren't any questions submitted, but folks, if you'd like to submit a question, just click on the triangle symbol next to questions on your GoToWebinar control panel and go ahead and type in your questions now. And while those questions are coming in, we did have a comment earlier on in the presentation from Harry Morgan. I understand the largest is the LA jail and second is Chicago, and he was referring to that comment earlier about basically mental health about correctional settings being mental health institutions. We also have a statement from Craig saying very helpful information that all clinicians know. And then the next is a comment and a question from Denise. A public defender in Palm Beach County hired her to see one of the clients for treatment instead of forensic evaluation or forensic assessment. She treated a young man in jail for trauma issues. Unfortunately, he was transferred to another jail at the end of the treatment process. She doesn't know the outcome. Is it against policy to follow up with therapists?
For the attorney, is it against policy for the attorney to follow up? Is that the question?
I believe it is, but Denise says yes, that is the question.
Okay. I don't believe so because, again, and that's actually going to go into part two is, the importance of the partnership between the two. What if what you did helped that attorney get a great result for that client? And what if that client, in that client's best interest would be to see you after he or she got out of jail? So besides just the natural kind of curiosity of wanting to know if what you did helped, I think it can actually benefit the client, as well for that continuum of care. So I think they should. And what I do is I make sure that we do take that team approach, and I handle cases in Palm Beach as well. And they seem, Palm Beach and Miami tend to be just better overall than Broward in the middle. But yeah, I think it should be part of the team approach. We're all in this together. And of course we want to, you folks want to know and want to continue to help. So for my clients, we do. But, the problem is public defenders, they're overworked, they're underpaid, just like prosecutors. And they don't have kind of the I don't know about the desire is not the right word, but they really just don't have the time to really bond and have long-term partnerships with their clients. A little different, I believe, when you're a private attorney. You have a business to run, and part of running that business is building relationships, and staying in touch with your clients and doing putting a lot of things in place where those clients then can know that you as the attorney, create a safe place, a safe environment for them to ever just forget about a rearrest or something, but just to call and follow up and be the center of influence in that person's life to put them in touch with various other services that they may need or other attorneys or really anything to help and better them. So that's just what I believe.
By the way, Craig clarified earlier, he meant to say very helpful information that all clinicians should know, not that they do know necessarily. And
okay, I was going to ask about that. Okay, good.
I was wondering about that too. Then also Thomas, to follow up with the attorney, the substance abuse and mental health clinician needs a signed release of information for the attorney and therapist. That's a comment being offered by Thomas.
Right. And assuming, that exactly, and this is what I get into in part two, is making sure that all the HIPAA release forms are done, all the, the attorney confidentiality stuff is taken care of. And those are things that I talk about in part two of how to do it, why to do it, and just things that, if you do it in the very beginning, right, it's done, right? We don't need to worry about it at the end, because at the end of the case or at the very, it becomes a pain in the butt, right? People don't want to deal with it, don't want to do it then. So,
Denise clarified that in her scenario, the release work was done at the inception. Jennifer said a mental health versus a psychological evaluation acceptance in most cases depends on a misdemeanor versus a felony, etc., except for competency. That's forensic as mentioned. I'm not exactly sure. I'm not quite sure what you're getting at with that comment, Jennifer. I personally don't see a difference between a mental health evaluation and a psychological evaluation, except terminology, really. In terms of content, I think they're both really the same. But I don't know if you might be talking about maybe clarifying whether the evaluation has to be conducted by a psychologist or whether it is acceptable from a licensed mental health counselor, maybe.
Right, and if I may on that as well, if we're dealing with what we call a downward departure which is an open plea to the judge on a felony case, saying that, you know, we have our own criminal punishment score sheet and guidelines, and let's say the minimum of the guidelines call for 3 years in prison and the max calls for 15, we might file a downward departure under one of various grounds, saying, judge, you know, we're asking for probation and treatment, and here's why. You know, then we might want a comprehensive psych eval by a forensic psychologist. But if we're talking about, you know, me and the prosecutor, just me as the attorney trying to get mitigation, trying to build, you know, a file of mitigation and treatment, so that way the prosecutor and I can just agree to our own downward departure or agree to our own sentence, or use that to have a felony charge reduced to a misdemeanor. Sometimes we do use comprehensive psych evals from forensic psychologists. Sometimes, depending on the situation, we can just use a regular mental health counselor, clinician, LMHC, whoever it may be, who's been treating that person long term and has more in depth about that person and the issues over a 6-month, 12-month period than maybe a forensic psychologist would, just from doing one evaluation. So there's a lot of different ways that we as attorneys can use it.
Jennifer,
so that's
it looks like
from my perspective.
It looks like from your most recent comment in the box here, it looks like that Adam is answering your question. But if there's more to that question, then let me know, and we could also unmute you and have you clarify the question as well. One thing I wanted to throw in, Adam, about what you just said is, I have a perspective really that appropriately trained licensed mental health counselors should be just as, that their evaluation should be just as widely accepted as that of a psychologist. So for example, some licensed mental health counselors are also certified forensic mental health evaluators who conduct very in-depth and thorough, comprehensive mental health evaluations, and are perfectly, here we can administer and interpret psychological tests just as psychologists can. And I'm only aware of one prohibition. There's a Florida statute that says, to the extent possible, the court shall appoint a psychologist, psychiatrist, or physician to conduct competency, civil commitment, and criminal responsibility evaluations. But that statute, number one, only seems to apply to court-appointed evaluations. Number two, only to 3 types of forensic evaluations, not downward departures, for example, don't seem to be covered in that statute. And then number 3, the verbiage, to the extent possible, seems to be interpreted in different ways by different districts. So in some counties, LMHCs are being appointed by the court to conduct even those 3 types of evaluations, and in other counties, they are not. For example, Hillsborough and Pinellas County, you won't see LMHCs being appointed by the court for those 3 types of evals, but you will see it on the East Coast, in the Daytona Beach area, you'll see it in the Keys, you'll see it in a lot of the rural counties too, especially where there are shortages of psychologists. I was wondering, I don't know how it is in your area, Adam, or if you have any opinion on that or experience with it.
Well, down here in South Florida, there's its own kind of separate business of, in each, we have people on a wheel that can be appointed, and then there's for those competency evaluations, and usually they're forensic psychologists. From everything that I've seen, that's exclusively what they've been, but that doesn't mean that I don't know every single person on the court-appointed wheel. But there's really also the private defense bar we go to. We have about 3 to 5 in each county that are our go-to for those competency. But of course, the competency is far end of the spectrum. From me with my cases, I may have 1 or 2 incompetent clients a year, but I may have 15 to 30 a year that I want in, maybe even 50 a year that I want in treatment, whether it's with an LMHC, with individual therapy, or a combination of anger management and classes and therapy, for negotiating with prosecutors, for open pleas with judges, which from what I deal with, we deal with those a lot more. Public defender's office, they have more incompetent clients, than usually I do. But yeah, to me, it doesn't matter, as long as it's somebody the client's comfortable with, as long as it's somebody, you know, that is going to do a, you know, not just an okay job, that's going to do a fantastic job and really fight, you know, and fight for the client, support them, I'm all for it. You know,
for those who are interested in this issue, by the way, you may want to know that the Government Relations Committee of the Florida Mental Health Counselors Association officially voted that we're going to target that statute in our lobbying coming up. We think it's an obsolete and outdated statute, and that the important issue shouldn't be what type of a licensed mental health professional you are. It should be whether you are individually trained to competently perform that type of evaluation. So we're hoping to target and clarify that statute. Jennifer did say that she gets a lot of pushback in circuits 4 and 7, and she said she does a lot of forensic work, primarily family, but is also being asked to do criminal. I do a lot of downward departure evaluations in my practice, but those are being hired by a defense attorney, and not a court-appointed like competency evaluation or something along those lines.
And so the Fourth Circuit, that's Jacksonville,
very much,
right?
What's that?
Jennifer said the Fourth Circuit, I think that's Jacksonville. Is that correct? 7th, I'm not sure.
Yeah, I don't know. I know you can't do it in the 6th. They will only appoint psychologists there. But I know quite a few LMHCs and quite a few counties that are being appointed by the courts for even competency evals. In fact, for some of them, that's the bulk of their practice. So it all depends on what jurisdiction you're in right now, it looks like. And Jennifer did say, yes, 4th is Jacksonville.
Okay.
Looks like for right now, anyway, those are all of the questions and comments coming in, but folks, feel free to keep adding to the questions box. And then when we get to the second Q&A section, I'll be glad to read them on your behalf.
All right, perfect. Thanks, Aaron. So we have, part 2. So, and this is really the importance of the sound partnership, right, between attorney and mental health / substance abuse professional. You know, why does anybody care, right? You know, we can learn about the system, but why should you and us work together? Okay. And the way we look at this is, you know, we are our 2 pillars. You know, we're supporting the same structure. We're supporting the same client. Like I said earlier, when we first started this, you definitely don't want your, you know, somebody who's been seeing you before me, right, before ever being involved in the criminal justice system, to see you on a Thursday, find out they went to prison, and say, oh my God, I could have done so much more. And I've seen firsthand a change in my practice over the last 3 to 5 years, when I've really embraced this and embraced therapists and substance abuse counselors, and, you know, as more than just, oh, okay, we got to do X, Y, and Z to help the client. Is really seeing clients who, from day one, I know it can help, right? It may help the case. It may not even be needed in the case, but if it helps the client, and then if it helps the client get better so that they don't reoffend, you know, it's helping for them and any potential future cases, or really preventing future cases. So it's so important for so many different reasons. So how can we help, right? Or how can you folks help? Really, education. You know, we're scared of you. Okay, as surprising as that might sound, we don't know you. We don't know what goes on in your world, and I know most of you are scared of us, which I've always kind of laughed at why people are scared of lawyers. I don't think you should be, you know, but we're just as scared as you are. Okay, and it's really important to establish trust with the judge and the prosecutor, as I'll get into a little bit. There tends to be with certain, I've seen certain judges and certain prosecutors' office, they have a natural actually distrust of substance abuse and treatment, you know, mental health professionals. Okay, and the easiest thing to do, and Aaron, I don't know if you've ever, like, how involved you've been on your downward departures, but what I've seen time and time again is when you go into a downward departure, or you're asking the judge to do what I call too much, when you're asking the judge to come up with the whole plan, judges get frustrated. They don't have time to do all of the work. But when you have everything, when the lawyer has everything set up, and the lawyer can say, Judge, this is the plan. This is the short-term, medium-term, long-term plan. These are the facilities. These are the treatment professionals. This is, you know, we have everything put in place. And judge, all you need to do is just sign the papers, right? More likely than not, you're going to get a favorable result than when the lawyer is unprepared or there's not a comprehensive plan in place. You know, there may be some letters and showing some treatment, but the judge is going to say, well, what am I supposed to do with this? You know, so that's something too that, and look, a lot of us, we might not know or understand a full comprehensive plan. And again, that's a way that you folks can help us. You know, for especially my contemporaries that aren't as familiar with the system, right? And also helping us better interact with our own client, you know, making sure to build the trust, you know, and build that relationship. Now, here's another video. This is the second video I'm going to play. This is a short clip of the entire incident. But this is an example of a judge, and this happened last year in Broward County as well. And this is, I think, an example of a judge being extremely insensitive, a judge who, you know, she was a family judge for a long, long time, and this is her not in family court, but this is her at first appearance court, magistrate court on a weekend, on a Saturday, I think it was a Saturday morning that she was there. And you know, most judges and lawyers, again, we don't receive special treatment, or I'm sorry, special training on the different levels of treatment. We don't know the best course of treatment. We might not know why, you know, one treatment is better in one case than another. And here's, you know, here's an example of a judge from last year in Broward County. Again, it's the short version, but if I played the longer version, it would only be worse. So here, let me play this, and hopefully you guys can hear it. Wait, hold on. Okay.
Don't even say yes. Excuse me.
Is this the meanest judge in America?
Excuse me. Don't say anything beyond what I am asking you.
There's nothing nice about the way Judge Marilee Ehrlich yelled at a woman with chronic obstructive pulmonary disease who's accused of scratching her daughter during a domestic dispute.
Ma'am. Ma'am.
At one point, the defendant starts coughing.
Can someone there give her water as a kindness? Ma'am, I'm not here to talk to you about your breathing treatment.
The public defender was outraged.
If somebody had done this to my mother, I don't even know how I could contain myself. And this is somebody's mother. It is unacceptable.
In a stunning turn, 3 days after facing Judge Ehrlich in a Broward County, Florida courtroom, the woman, Sandra Faye Twiggs, died of her condition.
Ma'am. Ma'am.
Now, can everybody hear now?
Yes, we can.
Okay, perfect. So that was just a quick minute clip, but that went on for about 10 to 15 minutes of her just screaming, yelling, and berating that woman. It happened, as you saw the date, I think it was 4/15 of last year, so it was very new. This judge was about 2 months away from retirement, and once this got out, the chief judge banned her from the courthouse. And then before the whole complaint process could go through, she just announced her retirement, and effective 2 months before, and quit, and really never came back to the courthouse. I never practiced before her in family court, but from what I heard, it was like that in family court all the time. So these things unfortunately do happen. It's not, they shouldn't, but even as you can see, it's not beyond a judge to act that way and to treat people like that. So the next thing is judges and prosecutors don't trust therapists. Now, not all of them, but a lot of them do, don't trust therapists. They believe that you folks are chosen by us and we're going to pick, the ones that find everybody incompetent, or the ones that are always going to, say that, hey, don't put this person in prison, and, and so on. The criminal justice system in the state of Florida for adults is punishment focused. The main goal is punishment, is to protect society, and that's what judges are taught. Political motivations. Judges are elected by the public. Now, there's two ways to become judges in a state court, whether it's county or circuit judge in the state of Florida. Not talking about the appellate courts, but just a regular judge that, county or circuit that you or I or most people deal with, would deal with, from a traffic ticket to murder. They're either appointed by the governor or they're elected. But even the ones that are appointed by the governor have to run for re-election, and they're appointed or elected to 6-year terms. So they're always running for re-election, and unlike people in the Florida House and the Florida Senate and US Congress, they're not natural politicians. Some judges are, but most are not. And what they're going to do is they're going to err on the side of caution, a lot of them. And unfortunately, their caution is jail, right? They don't want to get bad press from the newspaper, from the Sun Sentinel, from the Palm Beach Post, from whatever your local newspaper is, where they're saying, well, Judge so-and-so let that person out and that person committed a murder. And they are very, very aware of that in most of their cases. Another thing is a lot of therapists submit formulaic documents. It's kind of like when I read certain police officers' police reports, and it's the same template, and they just, switch up the name and switch up very minor little things. And we all, in my field, we know which cops do that. And a lot of therapists do that as well. And these judges see that and they know that. So here's an example of a letter. And this letter is okay. It's not amazing. It's not terrible. But this is just an example of one that we've had where I think therapists can do a better job. Okay, again, that one is not terrible. I have some other ones that I probably should add to it that are just laughable. But judges are used to seeing the same exact things, so we have to give them more. We have to give real details. So how do we establish this trust? Well, we must humanize, right, the defendant or the client, but we have to provide more details, supporting materials, explain why. I think the why is underexplained by therapists. Okay, why will one course of treatment, work? And of course, we know there's no guarantees, right? But really dive into it a lot deeper. Cite statistics and studies, if you know of, that show that one form of treatment is better than another. From the people that I talk to, especially for trauma, I know the big thing is EMDR treatment, and I don't know much about that at all. I'm still learning, but from people that I've spoken to, they seem to get great results. Well, are there any scientific studies about that, or about hypnosis, or whatever, if you have a specialized treatment or just even regular treatment? It's important to get those statistics, right? So that way we can show the judge and we can really advocate on behalf of our mutual clients. Some cases, it's helpful to go the extra mile. So if you can do a comprehensive psych eval, talk to the attorney about doing it. If you can do a biopsychosocial, talk to the attorney about actually doing it, instead of just writing the typical therapist letter saying, I've treated so-and-so for this long, and this, and this is an example where you as the therapist can educate the attorney and say, well, listen, we can do, an extra type of evaluation if you want. Of course, I'm sure there's additional fees for you and the client would have to do, but you can say, look, I think this might help, to really let the judge, give the judge or the prosecutor, an actual evaluation maybe for mitigation, maybe so the way, if it's, let's say it's a DUI case, right? And the attorney's trying to get the charges reduced to a lesser charge, maybe like a reckless driving charge. And it's close, you know, there's some arguments for, some arguments against. Maybe the prosecutor's case is a little on the weaker side, right? Well, it's going to help if that lawyer can give the prosecutor an evaluation that's going to say, look, this was more of a situational incident, a one-time incident, versus a chronic, you know, a chronic substance abuse problem. And we can cite 2 different tests that were given, different, you know, parts of the evaluation, whatever the specifics that you folks can do. That could be the thing that the prosecutor can take, put in their file, and say, all right, we'll reduce the charges. We'll give X, Y, and Z, because now we believe, right, from the prosecution that we are protecting the public versus letting somebody off with a slap on the wrist and they're going to do it again and kill somebody. Okay, that's always in the prosecutor's mind. You know, and again, you can do like what I was saying, a substance abuse evaluation, and put together a full-on treatment plan. But don't be afraid as a therapist to say to the attorney, look, I have some suggestions that might, you know, what we can do for this person. Okay, and if the attorney doesn't care, you know, then that person might need a different attorney. Appear in court if necessary. So I know therapists get scared about this magical, scary thing called court. Well, in the criminal field, personally, I don't think it's scary for a therapist. You know, I can see it being worse in child custody issues, dependency court, but you know, from every downward departure motion I've ever been to, it's other than the generalized anxiety and fear of an unknown or something unfamiliar, those hearings are not scary for the therapist at all. Aaron, you know, I know you said you do a lot of them. I don't know if you have a differing opinion of the way the judges deal with it in Hillsborough and Pinellas on the other side, but down here, nobody is grilling the therapist, or, you know, to any level where that person should be worried, you know, other than just kind of being unfamiliar with it. Okay. But there's no there's no substitute for the judge to see you and hear you, because if they don't see you and hear you, you're just you know, you're a something, right? You're not a real being. You're not a real person. You're just somebody who wrote something down on a piece of paper. You know, there is no substitute for the judge to see you, hear you, and that judge may have 2 or 3 follow-up questions. And imagine if that judge asks you those follow-up questions and you knock it out of the park and you get another chance to really advocate for our mutual client. You could have been, by you being there in court, you could be the one that saves that client. Okay. So I love it, and I strongly encourage all therapists, substance abuse providers, everybody in your field to come to court as often as possible. And it just takes a simple, you know, 20-minute call with the lawyer for the lawyer to properly prep you. Okay. And look, and if you are your own business owner, you should be compensated for that time. Absolutely. And I think there's nothing wrong with being compensated for that extra level of service. And I think the client and their families will gladly pay for that extra level of service if it is going to help them get a better result. So I don't think there's anything wrong with that. Now, how can you help improve the interaction? You know, these are some things that we've talked about throughout the course of this, that, you know, we really don't receive much training at all. You know, 0 or slightly above 0. Okay. You know, we don't know how to spot a potential relapse. We don't know what types of interactions may trigger, you know, specific behavior, such as a panic attack, or, you know, push them back to drinking or doing other destructive behavior. We don't know when to take certain client statements or threats, you know, seriously. These are things that we have very, very little training in. You know, we don't know what the best course of action is for the client. You know, we may have some generalized ideas, but how are we to know the specifics? You know, we're very good at what we do, but we're not really taught anything about your field. Okay, so those are ways that you folks can really help us, educate us. Okay, every conversation that you ever have with a lawyer should be, an extra 5 minutes, right, or longer, to take the time to educate the lawyer. Okay, especially on the mutual clients, their current state, the treatment. Keep us updated. Okay, you cooperate with HIPAA, cooperate with it early. Okay, the best time is the first time, right? Or the, you may have a long-standing client who then you find out gets in trouble. Well, use that as an opportunity as soon as you learn about it to say, hey, Johnny, and ask them to sign the forms, right? And so we can be compliant with all of that. I really see very few scenarios where the client is going to not want to sign that form. Okay. Alert the attorney to any behavior that can trigger a negative reaction. If that client has some sensitive issues, let us know, because it might not be readily apparent. They may be hiding or masking those issues when they meet with us. Okay. Let us know, when to take certain threats seriously, and give us tips on how to spot a potential relapse. And when we do that, it's a win-win for everybody. We have better results for our mutual clients. We have a true team effort. Okay, and I think that is way underutilized. It can't. Plenty of cases where we do our thing and we get great results, but I truly believe in, for the right cases, the right clients, you need the whole team involved. And we're not talking just now, right? I may win a case today, fantastic, but for the lawyers and therapists that truly care, we're looking at medium, long-term growth, long-term goals, long-term success. And I think sometimes, especially lawyers and especially our clients, they're looking at the here and the now, the big giant hurdle that's facing them now. And you really have to get them to take a step back and take a wider view of things. And of course, a court system that, it's everybody overworked, underpaid, stressed out, especially when you have the Florida Supreme Court last year telling county court misdemeanor judges, you need to trim your case numbers. If you have 1,500 active cases, you need to get that down to 750. The courts are too busy. They're hemorrhaging, right? And when judges get those directives, they want to go fast, and we need to get them to slow down for our clients. Okay, we need to get them to slow down to really understand what we're dealing with here. We're dealing with people's lives, people's freedoms, people's futures. So when we do that, hopefully we can make the system better, help our clients, and work together and do a tremendous, fantastic job. So that's the end of part 2. I know we covered a lot of that in part 1 as well, and during some of the questions, but what other questions do we have?
All right, so far we don't have any new questions. We have a couple comments I'll get to in a moment, but folks, go ahead and type your questions into the questions box. This is your golden opportunity to ask questions to a qualified attorney on a webinar, and
it can even be a story or an example of where something, if somebody has another example of a case where it went really well, or there was a mistake involved that they think that should have been done differently. Feel free. We got 15 more minutes. I think we can have even if there's not many questions, we can just have a generalized discussion about it.
Denise did offer a comment a little ways back. It was kind of a follow-up to what was being discussed at the time. She said, that's exactly why the local prosecutor hired me. He wanted a treatment summary with an understanding of how the client got to where he is today, the treatment provided, and the outcome.
Well, that's a great prosecutor. Okay,
Yeah.
That's great. So Denise, where was that? Was that in the 4th or the 7th Circuit?
She said West Palm Beach.
Oh, okay. So Palm Beach, so 15th. My wife's a prosecutor up there. Maybe it was her. So I know she cares about this too. So, but yeah, that's fantastic. So Denise, may I ask what kind of case was it? Was it a serious felony?
We can also, if it's easier, Denise, I could unmute you. I'm going to go ahead and unmute. And would you like to tell us a little bit more?
Yes, I was approached by the prosecutor's office and asked if I would be willing to treatment. Can you hear me okay? I didn't ask.
Yes, I can hear you.
Okay, I was asked if I would be willing to provide treatment instead of just doing a forensic assessment, that they found the forensic assessments were, not enough depth in really understanding the client. And so my first case was at the gun club jail. I was kind of surprised I was going to go to the jail, but I ended up there. And the young man was 21 years old, and he had already served a sentence for, he was in really young, he was 16 in a drug deal where he shot somebody, and he had already served his time, but he was on probation, and there was a weapon found near him at a train station. Now, he denies that the weapon was his. I don't know if that was true or false, but the attorney said he had a lot of trauma in his life, a lot of death in his background, and thought maybe some therapy would help him, make better life decisions. So I went to see him, did EMDR, by the way, with them, which I had to explain to the jailers to let me sit next to him so I could administer the treatment. Yeah, they kept saying, you're too close to him. And I said, well, I can't do MDR without being close to him. So, and he responded very well. Took a lot of heat out of reactive feelings, because he said he was really feeling certain things that he couldn't control, and that it took the heat out of those feelings. So if I even improved his ability to be where he was by not being reactive to other people, I felt that was a success in and of itself. But he was very responsive. Yeah.
Good. And I can't. It was great that the prosecutor was the one that wanted you. That's great.
And I got enough information to really write the story in the treatment summary. I wrote a story about what happened to this young man from age 7 up to build the picture for the prosecutor to truly understand why he got where he got so quickly in his short life.
Now, do you know what happened afterwards, or was this the one that you were talking about that you didn't know?
He got transferred to another jail on my last visit. So when I showed up, he was gone. And he transferred to another part of the state. So I don't even know if the prosecutor knows what the deal was.
Gotcha, yeah.
But he was trying to get him a lesser sentence for the break-in probation. That's what it was.
Right.
And that's what you call down stepping, or down, what did you call it?
Downward departure.
Well, downward departure, yeah.
That's the term. I've never heard that, so it's good to know that terminology.
Right.
Denise, I can go ahead and remute you. Thank you very much for sharing about that. And we also have a scenario and a question in from Craig. And what's kind of interesting about this one is that, Adam, you and I were talking right before the webinar about things that therapists often have questions about.
Right.
And here's one of them that we talked about, actually. So Craig says, parents often bring their child in for treatment without the other parent. I always tell my students to secure information from the missing parent. Your thoughts on this? And he adds an agreement for treatment, and he's referring to underage clients, minors.
Right. So, and that is exactly one of the things we were talking about. And so that, you might actually have that, Aaron, that answer, because that's
I do.
Out, right, and that's out of the realm of my knowledge as a criminal defense lawyer. But there's definitely lawyers that specialize in more of the ethics, and I know you guys have your governing boards with that. So that'll probably be better for you to answer than me.
Sure, I'll tell you. So, Craig, this all starts with a Florida statute 394-459, and in that statute, you will see 3A1, express and informed consent for admission or treatment of a patient under 18 years of age shall be required from the patient's guardian unless the minor is seeking outpatient crisis intervention services under statute 394.4784. All right, so at first glance, people say, okay, so we know that there needs to be, it just says the guardian, the parent or guardian, but it doesn't say both, but it doesn't say not both either. And this, of course, created quite a bit of confusion. Now, as it stands, there is a Florida Supreme Court case on this very issue that clarifies that statute. That case is case number 1D15-4217, which is Emad S. Angeli versus Evelyn A. Kluka and the Nemours Foundation, or the Nemours Children Clinic. Anyway, in that case, the court clarified that you only have to have one parent's consent. You don't need to have both parents' consent. However, there is another caveat to that, and the caveat is if there was a child custody case and now there is a parenting agreement in place, because in that scenario, the therapist should get a copy of the parenting agreement and they should check to see who did the judge say gets to make choices about health care for the child. If the judge says both parents must agree on any health care, for example, then in that scenario you need both. But if it doesn't say, then you wouldn't. Now, as another caveat, there are some scenarios which some of you may know about where minors don't have to have either parent's consent. Minors can actually self-admit for treatment. That's crisis services, short-term crisis. And then another scenario is voluntary substance abuse treatment, where the minor actually is the legal custodian of their own confidentiality, and where they can also be the ones who consent to treatment without either knowing. So hopefully, Craig, that answers that question. But if you have follow-ups, you can let us know. Jennifer says, oh, I can address this topic in depth. And then she says, perfect, unless there's been modification. So Jennifer, sounds like that all sounds good to you. If you have anything you want to add to that, though, or correct on it, then feel free to let us know, and we'll throw that in also. Craig says, it does, assuming you document the points you identified. So I'm not exactly sure what you mean by that, Craig, but I can also give you guys the statute, the court case, again, if you need it by any chance. So far, oh, so Craig said yes. Okay, so I'll give it to you guys again. In fact, what I'll do to make it a little easier is I'll type the information into the questions box here, so it'll be easier for you guys. Actually, even better, I can send you the document from the Supreme Court itself. I'll post a link for that in just a moment. Now we have Denise. I also put him into my informed consent form that if both parents sign consent to treat and one parent changes their minds after treatment's begun, this therapist reserves the right to continue treatment if it would cause the child more harm than good. Okay. Jennifer says, sometimes parenting plans are modified and a parent will send the old plan. That's a great point, Jennifer. Sometimes you don't even know that there's a parenting plan. So anytime I have a scenario like this, I'm always going to ask, is there a parenting plan in place? And then try to get the most current copy of it. Let's see what else we have here. We have a comment from Beatrice saying this is an excellent presentation, but that is, oh, here's from Jennifer. Also, the parenting coordinator required. Okay.
Well, thanks, Beatrice.
Right now, I don't see any other questions, but folks feel free to chime in. What I might do actually because it'll take me probably a couple minutes to create the link and send it, is everyone who completes the evaluation form today, we will send you in the follow-up email the documentation about that issue with minors and treatment. I also have a really nice email from FMHCA's chair of the ethics committee, where he addresses this issue in depth and all of the different nuances of it. So I can include that in the follow-up email as well. So while we're waiting to see if there are any last minute questions here, I'm gonna also remind you all to complete the webinar evaluation form, which will appear on your screen after I'm done talking and after we close the webinar today. If you miss it, you'll have a second opportunity, as the link to that survey will arrive in a follow-up email that we'll be sending you in 1 hour. Please complete that evaluation form within the next few hours so we can input your CE information into CE Broker tonight. If you have questions after the webinar, feel free to direct them to me. My email is anorton@flmhca.org. And we really hope you'll join us for our next webinar presentation for our 2019 Emerging Issues in Mental Health Counseling webinar series. That webinar will be entitled Lesbian, Gay, Bisexual, Transgender, and Queer Youth, Family Acceptance and Emotional Development. It's with Julie Basulto, a licensed marriage and family therapist, on Friday, August 23rd, from 2 to 4 p.m. Eastern Time. To register, visit our website at fmhca.org. Also wanted to let you all know that we are currently accepting applications for our 2020 webinar series. So please go to our website, or if you can't find it, just email me, and you can submit a proposal for a webinar for 2020. And you can feel free to share it with colleagues who you think would be great presenters for next year's lineup. Several people are saying this is a great presentation. Jennifer says, great presentation.
Oh,
thank
perfect.
you.
Thank you. Well, thank you. I'm glad, you folks loved it. So I'm all about trying to get, more information out there.
Yeah. Denise says, wonderful. Craig says, very helpful, and thanks for going outside the workshop focus. Thanks to you both. Nicely done. Harry says, thank you for an excellent seminar, most helpful. Thomas has a question, though. Oh, by the way, Jennifer says, great advocacy. Thomas's question is, do you know of any networking trainings or meetings where clinicians can meet attorneys? I've gone to some with another Florida law firm. Thanks for a great presentation.
So there's really not a lot. I mean, I know, I have down here in South Florida, I have a few friends. That's one of the other ways that I got into this world, is because I have a few friends that are LMHCs, and and I would just talk to them about what I would see in the disconnect, and then they started inviting me to their networking functions. And the ones that I go to, usually there might be a lawyer or two who specializes in Marchman Acts. There might be a lawyer or two who specializes in divorce, and then usually there's me. I'm the only one who specializes in criminal defense. But no, it's not. They're not easy to find, and there should be. What I would say is, the best way to do it, if you can't find one, start your own. If you got a bunch of people in the community, if you live in an area where you know a lot of them, then it can't hurt to start your own. I mean, me personally, I'm always looking for places to speak. I've spoken at FMHCA's conference this year in February on a different legal issue. I spoke on this exact topic last year at the Florida Behavioral Health Conference from FADA. I'm actually going again in less than a month at this year's Florida Behavioral Health Conference on the same exact topic. So I'm out there trying, but I might not be in your community. So it's just something you can try, right? If you want to do it, you can always find a way, or talk to maybe other people in your community, and it might not happen overnight, but but there's a way to get it done, I'm sure. So and let me know if you're close to South Florida. I love coming out and meeting people and speaking at different groups. It could be 10 people. If it's close, I'll come out. I love it.
I also want to let you all know I did go ahead and post a link both in the questions box and the chat box that has some documents related to that issue about treating minors. It includes the Florida Supreme Court case. It includes an email that I wrote to my interns outlining this, and an email from Michael Haller of our ethics committee on the issue of treating minors. So that is in both the chat box and it is in the questions box. Speaking of questions, we have a comment from Beatrice. Collaborative team is a good group for family and divorce issues. Do you know, Beatrice, how to access that resource, collaborative team? Feel free to let us know. And I don't see any other questions or comments right now. So I think what we'll go ahead and do then is we'll wrap up today's webinar. Remember again that evaluation form will populate on your screen in just a moment here. Oh, Beatrice said I could send the link later to you. So you could do that, Beatrice, and then I'll make sure everyone gets it. Craig said thank you for the links. We're going to wish you all a very happy and fulfilling weekend, and we will look forward to seeing you next time on our webinar. Adam, thank you very much for sharing your expertise. Do you have a parting comment?
Well, first of all, it was my pleasure. I love doing this. And no, I mean, if anybody wants to contact me, is my contact information going to be sent to them? You always can. You can always call me, email, questions, anything I can do to help. And if I can help, if I can steer you in the right direction or put you in touch with somebody who can, it's my pleasure to do so.
We'll be glad to send your
for being here for 2 hours.
Yeah. We'll be glad to send your contact information as a follow-up. It's also in the slides in your handouts. I think you'll see it towards the end.
Okay, perfect.
Adam, do you want to share your website also with everybody?
Sure. You can go to www.rossenlawfirm.com. That's ROSSEN. It's my last name, lawfirm.com. You can find out all information about us there. I can even put it up if you want.
All right, beat you to it.
Okay. And it redirects to a URL that we have, but it's all there. And you can email me at adam@rossenlawfirm.com. It's easy to get in touch with me. And we're just one small piece to try to better our community. That's what we do.
All right, thank you so much. You all have a wonderful weekend. We'll see you next time.
All right, thanks, Aaron. Thanks, everybody.